requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
or policies as before us today to make it harder for law-abiding citizens to obtain firearms
from engaging in defense from imminent harm.
Large capacity magazines increase.
Simple. I will read, if I can find underneath all these amendments.
Background. In the wild world of gun laws, Illinois has been a bit of a hotbed lately, especially with this whole tango around restricting rifle mags. Picture this. Folks in Illinois got wind of these laws, trying to limit what mags you can slap into your rifles, and let's just say they weren't too thrilled about it. It all started with this big legal showdown. There was this major beef against the Illinois laws trying to rain on people's mag parade. The whole point was to limit what they call attack weapons and their accompanying mags. Basically, these laws were of their rights and freedoms. So that's where it all started, this clash between the Illinois laws and the folks who weren't too keen on having their mag options curtailed. And boy, did things heat up from there. Emergency application to Supreme Court. Imagine this. There's a ticking time explosive, and in this case, it's not explosives, but a law about to limit rifle mags in Illinois. So what do you do when you're facing a law that's about to cramp everyone's style? You pull out all the stops and head straight to the big leagues, the Supreme Court. That's exactly what happened here. The urgency was like a fire alarm going off because these folks knew time was running out. They saw this law looming on the horizon, ready to snatch away their freedom to choose the mags for their rifles. It was like a clock ticking down to disaster, and they needed a superhero-style intervention pronto. So they hit the emergency button and shot off an SOS to the Supreme Court. Their plea? Hey, Supreme Court, this Illinois law is about to rain on our parade. We need your help, and we need it now. Why the big rush? Well, these folks weren't just twiddling their thumbs. There was a legit reason for the urgency. They knew that once this law kicked in, it would start impacting everyone's rifle mag choices. And let's be real, once a law gets rolling, it's tough to put the brakes on it.
And no one contends otherwise. But what are the limits? Wouldn't it be nice to hear?
Requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
or policies as before us today to make it harder for law-abiding citizens to obtain firearms.
Year-old adults, guns that are in common use. It bans for everyone.
So they wanted the Supreme Court to slam the brakes before this law turned into a full-blown roadblock. Their reasoning? It was crystal clear. They believed this law was trampling all over their Second Amendment rights. They saw it as a direct hit on their freedom to choose the mags for their rifles. To them, it was like someone saying, "Sorry, you can't have your favorite dessert anymore." It's frustrating, right? And that's why they were pounding on the Supreme Court's door, waving red flags and shouting, "Hold up! This law's about to mess things up, and we need you to step in and stop it." The urgency wasn't just about their personal preferences. It was about defending what they saw as a fundamental right. So this emergency plea wasn't just a panic move. It was a last-ditch effort to prevent what they believed was an unjust law from kicking in and cramping everyone's style. They wanted the Supreme Court to be the hero and save the day before this law turned into a full-blown headache for everyone involved. Seventh Circuit en banc panel's denial of review. All right, so picture this. The legal showdown about Illinois' rifle mag ban was getting intense, right? Everyone's eyes were glued to the Seventh Circuit en banc panel, waiting for their big decision. But guess what? Plot twist! They slammed the door shut on reviewing the whole shebang. Now, why'd they do that? Well, the en banc panel basically took a hard pass on diving deeper into these challenges against the Illinois laws. It's like they looked at the whole mess and said, "No, we're good. We don't need to rehash this." But here's the kicker. Their denial of review? It's like a domino effect, setting off a chain reaction. This denial isn't just a shrug of the shoulders. It's a big deal. It's like waving goodbye to a chance for a second look, a second chance to make things right in the eyes of the law. The impact? It's huge. This denial ripples through the legal proceedings like a pebble dropped in a pond. It kind of seals the deal, at least in the Seventh Circuit's realm. It's like they're saying, sorry folks, no redos here. For those challenging the Illinois laws, it's a gut punch. It's a closed door where they were hoping to find a crack of light. This denial means they're running out of options within the Seventh Circuit. It's like hitting a dead end on a road trip. Nowhere else to go but to turn back or find a new path. The legal challenges? Well, they just hit a roadblock. It's not the end of the road, but it's definitely a detour they were counting on. They were probably hoping for a different outcome, maybe a chance for a more thorough review. But with this denial, it's like the en banc panel said, we're done here. So this denial of review, it's not just a meh moment, it's a game changer. It's like the Seventh Circuit slammed the brakes on these challenges, leaving those fighting the Illinois laws scrambling to figure out their next move. It's a setback, no doubt about it. But hey, in the legal game, setbacks are just opportunities to plot a new strategy, right? NAGR versus City of Neal. All right, buckle up for the specifics on the NAGR versus City of Neal case. It's a real roller coaster ride through the legal battlegrounds of Illinois' rifle and mag bans. This case, it's like the epicenter of this whole legal earthquake. NAGR and the City of Neal squared off in this battle royale, all about challenging the rifle and mag bans that Illinois thought were a good idea. Now, let's zoom in on the significance here. This case ain't just any old legal scuffle, it's a heavyweight in the world of gun rights. NAGR, with their gloves off and guns blazing, figuratively of course, was waving the banner for all those who felt their Second Amendment rights were getting a bit too restricted. What were they fighting against, you ask? Well, it's these bans on what they call attack weapons and their mags. NAGR was like, hold up, Illinois, you can't just drop these laws and expect us to sit quietly. They saw it as an attack on their freedom to choose what rifles and mags they wanted to use. But here's where it gets juicy. This case wasn't just about Neal flexing its legal muscle, it had way broader implications. It was like the big kahuna in a sea of legal challenges against Illinois' restrictions.
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
And yet at Uvalde and in so many other school shootings, we were not willing to protect our children.
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
From engaging in defense from imminent harm.
Large capacity magazines increase.
Now, within the broader context of all these legal battles against Illinois' bans, NAGR versus City of Neal stood out like a lighthouse. It was a rallying point, a focal point for those hoping to push back against what they saw as unjust restrictions. Sure, the outcome wasn't what NAGR and its supporters were gunning for, pun intended, but the fight they put up was a testament. It showed that people were willing to stand their ground and challenge these laws, even if the legal winds didn't blow in their favor. In the grand scheme of things, this case might have been a single chapter, but it was a chapter that echoed through the pages of the broader battle for gun rights. Its significance wasn't just in the legal jargon, it was in the determination of those fighting for what they believed was their constitutional right. So NAGR versus City of Neal? It may not have ended with fireworks and victory chants, but it sure left an imprint in the ongoing saga of Illinois' rifle and mag bans. It was a reminder that in the legal arena, each case carries the hopes and dreams of those fighting for their rights, And that is a pretty big deal. Previous denials of preliminary injunctions. Okay, let's rewind the legal tape a bit and dive into the saga of these preliminary injunctions that were basically the appetizer before the main course legal showdown. Picture this. Before the whole legal battle took center stage, there were these requests for preliminary injunctions. Now, what's a preliminary injunction, you ask? It's like a legal pause button, a request to halt the enforcement of a law until the whole shebang is sorted out in court. In this rifle and mag bans tussle in Illinois, those challenging the laws were like, hold your horses, courts. Before you let these bans kick in, how about hitting pause? We need some time to duke it out in legal land. But here's the kicker. Those requests for preliminary injunctions? Denied. Boom. Just like that, the court said, nah, no pause button for you guys. At the district court level, where it all began, these folks filed for a preliminary injunction. They were hoping the court would see things their way and temporarily stop the bans from rolling out. But nope, the district court was like, sorry, not today, and denied their request faster than you can say objection.
Simple. I will read, if I can find underneath all these amendments.
And their recent actions against firearms manufacturers, federal firearms licenses, or FFLs.
Striking a clause in the preamble is per se germane, neither adds nor subtracts, and police.
But now you secretly let out what the real purpose of it is. It's to claim that Democrats.
Bills for National Police Appreciation Week, we took up the actual bill.
Undeterred, they took their plea up a notch and appealed the district court's decision to the Seventh Circuit, the next stop in the legal train. They were crossing their fingers, hoping for a different outcome. But, you guessed it, lightning struck twice. The Seventh Circuit, too, slammed the door on these requests for preliminary injunctions. It was like a legal double whammy. Denied again. So those challenging the bans found themselves facing roadblocks at every turn. The courts were pretty clear. No temporary halts, no breaks in the action. It was like the legal system was saying, you gotta play by our rules, and right now, those bans stay put. And that's how we got to the current status, with these denials of preliminary injunctions serving as a sort of prelude to the bigger legal showdown. It's like these challenges face setback after setback, setting the stage for the uphill battle they've been fighting ever since. Those denials weren't just minor hiccups. They were like giant stop signs in the path of those trying to halt the bans. But you know what they say about setbacks? They're just setups for a bigger comeback. And in this legal drama, it's far from game over. Those challenging the bans? They're gearing up for the next round, ready to bring their A-game in the ongoing battle against these restrictions. Looming registration deadline concerns. Alright, imagine a clock ticking down to doomsday, but instead of the end of the world, it's the deadline for registering firearms in Illinois. That's the kind of tense situation we're looking at here. So what's the deal with this looming registration deadline? It's like this sort of Damocles hanging over gun owners in Illinois. The state slapped this deadline on registering certain firearms, and folks are feeling the heat because time's running out faster than a sprinting cheetah. Now here's where the anxiety kicks in. There are concerns, big concerns, about whether people are actually complying with this registration deadline. The stats? Let's just say they're painting a pretty worrying picture. It's like most folks are treating this deadline like that pile of laundry you keep ignoring. It's there, but you're not quite getting around to it. Reports suggest that only a tiny fraction of gun owners in Illinois are actually getting their firearms registered before the clock strikes zero. It's like the vast majority are dragging their feet or outright ignoring the deadline.
Registration for assault-style weapons now required by Illinois law.
Whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president himself.
In 100 counties that I don't think there'll be any prosecutions unless there's a much bigger case to be had there.
Pistol, it can become a short-barreled rifle, and then it's subject under the National Firearms Act. That's what you're saying.
Some liability exemption for their COVID vaccines, right?
I actually am not familiar with vaccines.
Well,
there is still plenty of confusion about who needs to register and just how the new law will be enforced.
Talk about playing a risky game of chicken with the law, right? And that's not all. There's this underlying fear that when the deadline hits, it's going to create a legal mess. Picture this, a bunch of folks not registering their firearms, a law that's about to kick in, and chaos waiting at the doorstep. These concerns aren't just about paperwork or playing by the rules, they're about the potential fallout. It's like a recipe for a legal hurricane. What happens when the deadline passes and a significant chunk of gun owners haven't complied? Will the state crack down? Will there be legal consequences? These are the questions keeping people on edge. This looming deadline isn't just a date on the calendar, it's a ticking time explosive of legal uncertainty. It's causing ripples of worry throughout the gun-owning community in Illinois. So bottom line, with this registration deadline fast approaching and dismal compliance rates, there's a cloud of uncertainty hanging over what happens next. It's like a suspense thriller waiting for that final chapter, and everyone's holding their breath to see how this deadline drama plays out. Supreme Court's earlier denial. The Supreme Court, the big dogs of the legal world. Picture this, there was this big legal showdown brewing over Illinois' rifle and mag bans, and everyone thought, hey, maybe the Supreme Court will swoop in and save the day. But plot twist, that's not how it played out. Initially, those challenging the bans looked to the Supreme Court like a beacon of hope. They filed this emergency application, basically pleading, hey, Supremes, can you step in and put a pause on these bans? Pretty please? But alas, the Supreme Court slammed the door shut on that plea. They were like, sorry folks, no emergency intervention for you. It was like a balloon deflating. Hopes were high, but reality hit hard. Now, after that initial refusal from the Supreme Court, the case didn't just fade into obscurity. Nope, it kept chugging along like a train on a track, albeit with a few bumps. The legal saga continued its wild ride through the courts, even after the Supreme Court said, not interested. It's like those challenging evolved into this legal tug-of-war, with each side trying to gain ground. Sure, the Supreme Court initially said, nope, not stepping in, but that didn't mean the end of the road. It was more like a detour in their legal journey. This whole progression after the Supreme Court's denial was like a roller coaster ride, twists, turns, and unexpected loops. But hey, in the world of law, it's not over until it's over. And this case, well, it's still got some fight left in it. Who knows where the next turn in this legal roller coaster will take us? Guess we'll have to buckle up and hang on for the ride. Recent filing and response. Recently, things heated up again in the legal arena over Illinois' rifle and mag bans. There were these flurry of filings and responses volleyed back and forth between the challengers and the state, all aimed at catching the attention of the bigwigs up at the Supreme Court. After the Seventh Circuit denied the en banc review, the challengers didn't throw in the towel. Nope, they played their ace card and fired off another round of legal missiles straight to the Supreme Court. Their message? Hey, Supreme Court, remember us? Things are getting dicey down here, and we need your help. They submitted this emergency application, essentially pleading for the Supreme Court to intervene. Their arguments were as solid as a rock. They claimed that the Seventh Circuit messed up big time. They were like, hey, Supremes, the lower court's ruling, it's a mess. They didn't follow the rules, and they're just not getting it right.
And Illinois State Police said they hope to have answers to some of those unanswered questions by the December meeting of the Joint Committee.
The gentleman from California is recognized.
Mr. Speaker, I yield 2 minutes to Jerry Nadler.
Before the ban took effect, are allowed to keep them as long as they register them before January 1st.
That's right. Under this bill, a conviction is not required. This will lead to bizarre consequences.
Right. The Sixth Circuit, I think, ruled yesterday. A panel of the Sixth Circuit. There's a prior en banc.
Administrative rules, which is just about a month from that January 1st registration deadline.
On the other side of the ring, the state of Illinois wasn't about to sit back and watch. They geared up, filed their response, and put forth their own arguments. Their stance? They were playing defense, doubling down on their belief that everything was just fine and dandy with the lower court rulings. The state argued that, hey, there's nothing to see here. They claimed that the lower courts did their job, followed the playbook, and made the right calls. They were basically saying, sorry, Supreme Court, but this case doesn't need your attention. We've got it all under control. Now, the challengers weren't having any of that. They fired back, highlighting the urgency of the situation. They were waving the flag, shouting, "This is a big deal! The lower court's goofed up and we need your intervention!" So in this back and forth between the challengers and the state, it's like a legal chess match. Each move, each argument, it's all about trying to sway the Supreme Court's attention in their direction. It's a battle of legal wits, with each side trying to make their case the one the Supreme Court can't ignore. The arguments presented by both parties are like puzzle pieces, each trying to fit theirs into the bigger picture. And now, the ball's in the Supreme Court's court. They've got these filings and responses in front of them, and it's up to them to decide whether to step into the ring or let this legal bout play out without their intervention. It's like a legal cliffhanger, and everyone's waiting to see what the Supreme Court's next move will be. Last line of defense. With the Seventh Circuit waving off the en banc review like a referee dismissing a challenge, all eyes are now fixated on the Supreme Court. It's like this legal drama has reached its climax, and the Supreme Court stands as the last line of defense in this nail-biting showdown over Illinois' rifle and mag bans. The pressure on the Supreme Court? It's palpable, like the weight of the entire legal battle resting squarely on their shoulders. With the Seventh Circuit bowing out, it's like they've passed the baton to the highest court in the land. It's a Hail Mary moment, with those challenging the bans hoping the Supreme Court will be their saving grace. Why is the Supreme Court's role so significant? Well, they're the final stop in this legal roller coaster. When all other avenues have been exhausted, when the lower courts have had their say, the Supreme Court's decision holds the ultimate sway. Their verdict can tip the scales in favor of one side or the other, shaping not just this case, but potentially setting a precedent for similar battles across the nation. Think about it. The Supreme Court isn't just another player in this legal game. They're the heavyweights, the ultimate arbiters of justice. Their decision can echo through the halls of legal history, influencing laws and rights for years to come. The pressure isn't just about this specific case, it's about the broader implications. It's about Second Amendment rights, about the balance between state laws and individual freedoms. The Supreme Court's ruling could draw the boundaries of what's permissible under the Constitution, impacting not just Illinois, but potentially the entire country. So as the challengers lean in, hoping for the Supreme Court to lend an ear, the weight of this decision looms large. It's a moment where the highest court's decision isn't just about legal technicalities, it's about shaping the fabric of rights and freedoms in the U.S. The Seventh Circuit's decision placed the ball firmly in the Supreme Court's court. Now it's up to the justices to decide whether to let this legal battle simmer or to step in and make a decision that could echo through the annals of legal history. It's a moment where the eyes of the nation are glued to the highest court, waiting for their verdict to be the final word in this high-stakes legal showdown. Arguments for Supreme Court intervention. The arguments laid out to sway the Supreme Court into intervention in this legal skirmish over Illinois' rifle and mag bans? They're like a legal chess game, each move calculated to convince the highest court that their involvement is absolutely necessary. First off, those seeking the Supreme Court's intervention are highlighting what they see as a colossal mess in the lower courts. They're waving red flags, shouting, "Hey, Supreme Court, the Seventh Circuit dropped the ball!" Their pitch? The lower courts didn't follow the playbook. They claim these courts bungled up the legal analysis, misinterpreting precedents and sidestepping crucial constitutional questions. Then there's the urgency factor, the ticking time explosive of that looming registration deadline. Those pleading for the Supreme Court's intervention are saying, this isn't just any legal tangle, it's a matter of immediate concern. They're stressing that this deadline isn't just a date on the calendar, it's a potential legal catastrophe waiting to happen. It's like they're waving a flag saying, Supreme Court, if you don't step in now, chaos might ensue.
I think it's going to be a problem for the governor and the ISP and ultimately the legislature to sort out.
People who own high-power rifles and other weapons covered under the Illinois assault weapons ban.
I believe hundreds of thousands of law-abiding citizens are just not going to comply with this law.
There have been a variety of balanced budget amendments that have been considered by Congress, but among the many troubling.
But gun owners today say that they only had some of their questions answered and pending legal challenges.
Moreover, there's this broader constitutional argument being flung like a legal boomerang. Those seeking intervention are arguing that this case isn't just about Illinois. Nope, it's about the fundamental rights of gun owners everywhere. They're painting a picture of a precedent-setting moment where the Supreme Court's involvement isn't just about this case, it's about setting the boundaries for Second Amendment rights across the nation. And let's not forget the whole last resort card. Those pushing for Supreme Court involvement are saying, "You're our only hope." They're emphasizing that this isn't just another legal bout, it's a crucial moment where the Supreme Court's decision could chart the course for future battles over gun rights. So, in a nutshell, those seeking the Supreme Court's intervention are painting a picture of legal chaos, misinterpretations, looming deadlines, and far-reaching implications for rights. They're laying out a buffet of reasons why the Supreme Court should roll up their sleeves and step into this legal minefield before it blows up into something much bigger. That's all for this video, folks. See you next time.